Good day, Crime Talk aficionados. My name is Scott Reich, and this is Crime Talk. We have a big show for you today, so let's give you a quick preview. First, a former Minneapolis cop gets sentenced, and then he has something to say at his hearing. An unusual case in Florida where the stand your ground law may come into play. The mysterious death of a Georgia mother. The Murdaugh case just got bigger yet again. A teen has been arrested for the alleged double slaying of two people. When I say let it go, this is an example of why you let it go, so you don't spend the rest of your life in prison. And then finally, our dumb criminal of the day. Let's talk about it. Good day, Crime Talk aficionados. This is Crime Talk. My name is Scott Reich. Thanks for joining us. You know the drill. Subscribe if you haven't. Like if you do. Hit that little bell so that you receive notifications when we go live or put up new content. And as always, leave me a comment below. And remember, you can always listen to us on any of your favorite podcasting apps. Just simply search Crime Talk with Scott Reich. All right. Now, another quick housekeeping matter. That's right. We have a sponsor back with us again, CrimeTalk Prep. So when you go to crimetalkprep.com, you're going to be able to save 20% on a 3-month food supply. Now, we've talked about this. I'm not some doomsday guy. I'm a realist, just like you have to be when you're representing clients. You have to be a realist. Here's the good facts, the bad facts, and reality. All right? Bottom line. And if someone had told me growing up that there would be food shortages in the United States ever, wouldn't believe it. Then you got President Putin saying that, hey, we may go nuclear in the whole war on Ukraine. How's that going to affect the world? Okay, this is emergency food supply, ladies and gentlemen, for emergencies. I hope none of us ever need to use it, but you want it there when the emergency arises, because guess what? When that emergency arises, it's too late to have. So you need to plan ahead. So go to crimetalkprep.com, order your 3-month food supply. You don't have to get 3 months. You can get more if you want to as well. But the point is you want something to take care of you and your family. The cavalry isn't coming. And if there's a big problem, it could take weeks, months. It's not going to be a quick fix. You need to be prepared to take care of yourself. So go to crimetalkprep.com, 20% off your emergency food supply. Support the people that support Crime Talk. All right, let's go ahead and open the docket for September 21st of 2022. Well, one of the 4 Minneapolis former police officers involved in the death of George Floyd had a bit of an outburst in court following his sentencing to 3 years in prison. That's right. The sentencing hearing saw former Officer Thomas Lane appear via video from the FCI, the Federal Correctional Institute, here in Englewood, Colorado, where he is now serving a sentence at the low security federal prison camp there in Littleton. There's actually a detention center, a higher security facility, and then a prison camp, which has no walls or fences there. It basically looks like you're going to summer camp over there. Pretty nice facility. If you got to do prison time, that's where you want to do it. Well, he got to appear via video for his state sentencing. Now, former Officer Lane made no statements to the court before the sentencing finished. But after the hearing adjourned, Mr. Lane lashed out at his attorney regarding the judge's decision that he would have to register as a predatory offender if required. He said, quote, "I have to register as a predatory offender? What the F is that?" Lane said. "That's what Chauvin has to do," he added, referring to his former officer, Derek Chauvin, who knelt over Floyd's neck for more than 9 minutes, ultimately resulting in his death. "If I have a minimal role, why the F do I have to do that?" Well, it's called complicity, and that's certain charges there with the law that he is sentenced under. So Mr. Lane is already serving a 2-year federal sentence for violating Mr. Floyd's civil rights. And when it comes to the state case, prosecutors and Lane's attorney had agreed to recommend a sentence of 3 years, which is below the sentencing guidelines, and the prosecutors agreed to allow him to serve that penalty at the same time as the federal sentence, concurrent. And Judge Peter Cahill accepted the plea agreement, saying that he would sentence Lane below the guidelines because he accepted responsibility, which is he pled guilty. The judge said, "I think it was a wise decision for you to accept responsibility and move on with your life," Judge Cahill said, acknowledging that the Floyd family has not been able to move on with theirs. Now, of course, you may remember the Floyd family got that huge settlement, and I'm sure the family members didn't take a penny of that. It all went to Mr. Floyd's children, so that they're probably taken care of. It'd be curious to see in the next 5 to 10 years how much of that money remains, or how much money did the family use to help raise those children. Well, anyway, under the Minnesota rules, it is presumed Lane would serve 2 years of his state sentence in prison and the rest on supervised release, commonly known as parole. Now, the state law also dictates that Lane register as a predatory offender, a status given to those convicted of felony criminal sexual conduct or certain other designated sex crimes, kidnapping, or false imprisonment. When Lane pled guilty to aiding and abetting second-degree manslaughter earlier this year, he admitted that he intentionally helped restrain Floyd in a way that created unreasonable risk and caused his death. As a part of that plea agreement, a more serious count of aiding and abetting second-degree unintentional murder was dismissed. In Lane's plea agreement, he admitted and stated that he knew from his training that restraining Floyd in that way created a serious risk of death, and that he heard Floyd say he couldn't breathe, knew Floyd fell silent, had no pulse, and appeared to have lost consciousness. The plea agreement says that Lane knew Floyd should have been rolled onto his side, and evidence shows he asked twice if that should be done, but he continued to assist in the restraint despite the risk. Lane agreed that the restraint was unreasonable under the circumstances and constituted an unlawful use of force. Needless to say, the attorney probably did not go over all of the consequences for having to register potentially as a violent predator. But he's going to vent his frustration, and what's he going to do? Asked to withdraw his plea? No, that's not going to happen. Next, an interesting issue on a potential Florida stand your ground case. So the family of a 19-year-old University of Tampa student who was shot dead while trying to get into a stranger's car following a night out says that they are still in obviously a shock as to his death. Carson Senfield was shot and killed at 1:20 a.m. on Saturday morning after returning to his off-campus home on West Arch Street in Tampa, following a night out to celebrate his birthday. He had just exited an Uber outside his home, and when he approached the other vehicle, a black sedan, which did not appear to have license plates in the photographs that are taken from the scene, and Mr. Senfield then approached and opened the rear passenger side door of the car. It's unclear exactly what occurred next, but the driver of that vehicle, who has not been named, said that they feared for their life and they shot the man. The man lives nearby, according to the police, but did not know Mr. Carson. Now, investigators have not revealed what he was doing in the vehicle at 1:20 a.m. armed with a gun and whether he was legally allowed to possess the firearm. Photos from the scene show a child stuffed animal in the sedan's back seat. The keys were still in the ignition as the police searched the car early Saturday morning. Now, in Florida, he can invoke the stand your ground defense and claim that he believed that Carson wanted to kill him. It is now the Florida State Attorney's job to determine if charges are appropriate, but the case is still being investigated as a homicide. Interesting issue. Stand your ground doesn't just mean your house. It doesn't just mean a fight or something along those lines. Somebody jumps into the backseat of your car. Are you in fear of death? Possibly. Could come down to ultimately a jury to decide whether that was reasonable behavior or unreasonable. Expose the guy in the car to criminal liability. We'll have to wait and see. Next on the docket, a bizarre case in Georgia. A police incident report has shed a little bit more light on the mysterious death of a Georgia mother found deceased last week in Clarksville, Georgia. So on September 10th, 59-year-old Debbie Collier sent her daughter $2,385 using Venmo and included a message that read, "They are not going to let me go. Love you." That's according to the police report. After receiving the message, Collier's daughter tried to call her mother but could not get in touch with her. The worried daughter then contacted the police to report her mother was missing. Investigators determined that Collier left her house with only her driver's license and a debit card. Last Sunday, police tracked a rental vehicle Collier had been using to a wooded area 60 miles away from the family Athens, Georgia home. Police searched the vehicle and the vicinity around where the car was and found her body in a nearby ravine. As investigators descended on the scene, they were joined by multiple family members of Collier, including her husband. He told police that he last saw his wife at about 9 p.m. on Friday, September 9th, as he was going to bed. The husband went to work on Saturday morning and told investigators that his wife's vehicle was still in the driveway at that time. According to reports, Collier's husband reportedly said she was sleeping in a different bedroom the night before she disappeared due to his snoring. According to the sheriff's office incident report, Collier's vehicle was found unlocked and unoccupied and parked on the side of the road on Georgia Route 15, which is north of Clarksville. A red bag with what appeared to be the remains of a fire was located near Collier's body. Now, police say Collier had been partially burned and stripped naked. She was found grasping a small tree, according to the police report. So far, no arrests have been made. Bizarre case indeed. We'll see how that continues to develop. Next, the Murdaugh case just keeps getting bigger. A federal grand jury has issued a second superseding indictment against Russell Lafitte, containing one conspiracy count, one count of wire fraud, and one count of bank fraud, and 3 counts of misapplication of bank funds. Lafitte was already staring down similar charges, but the superseding indictment increases the allegations against him, extends the time frame of the alleged misconduct, increases the amount of money he allegedly stole, and expands the pool of his potential victims. Now, in addition to the high profile Mr. Murdaugh is facing, Murdaugh is also staring down 90 individual counts of alleged criminal activity involving the scheme with Lafitte. Now, Lafitte, who appears to have been the key cog in Murdaugh's alleged financial crimes, was fired from his position as the chief executive officer of the Palmetto State Bank back in January. 3 months later, he was indicted on multiple criminal conspiracy charges at the state level in connection with the alleged role in various Murdaugh-related fleecings. In late July, Lafitte was hit with a 5-count federal indictment alleging bank fraud, wire fraud, misapplication of bank funds, and conspiracy to commit bank fraud and wire fraud. When I was reading the superseding indictment, it appears as though Mr. Lafitte was using the cases where he was appointed as the personal representative to loan money to other people to use money for his own financial shortages. That's right. He would write checks from the personal representative accounts to cover the overdraft accounts that he had. So here's a general rule. When you are a fiduciary like Mr. Lafitte was, you don't touch other people's money. There's a reason why it's held in a separate account, and you have a fiduciary obligation not to do anything that individual wouldn't do themselves. I doubt the personal injury clients who had settlements from the Murdaugh firm would loan the bank president money because he mismanaged his. But one word describes it as you read through the superseding indictment, and that is arrogance. All these people in this Murdaugh case, they thought it's clear. They thought that they were untouchable, that nobody would ever question a single thing that they did. And my guess is if they continue to dig and audit all of those accounts in which Mr. Lafitte and Mr. Murdaugh were somehow associated with, the list of cases and the dollar amount stolen will get larger and larger. I just want to know is who's paying his attorney's bills, because Murdaugh doesn't have any money. Lafitte doesn't have a whole lot of money. I mean, heck, he was writing checks to cover his mismanagement. I still think it's bigger down there than most people are talking about. We'll wait and see. Next, a teen has been arrested for a double slaying. The Orange County Sheriff's Office in North Carolina has arrested a suspect for the shooting deaths of 2 teens who were previously reported missing. Now, on Tuesday, the Orange County Sheriff, a guy by the name of Charles Blackwood, announced that a 17-year-old has been charged with 2 counts of first-degree murder, which are a Class A felony there in North Carolina, for the deaths of Devin Clark, who is 18, and Lyric Woods, 14. Now, through the hard work of the investigators, the sheriff stated, along with the assistance of personnel from many other law agencies, we have identified a suspect in this case. We will now work with local, state, and federal authorities to apprehend and present the suspect to the court system. The suspect, who has not been publicly identified, will not be charged as an adult due to state law that went into effect in December of 2019 and says that 16 and 17-year-old individuals who commit crimes in North Carolina are no longer charged automatically in the adult criminal justice system. Instead, the case will be transferred from a district court to a superior court. And then the sheriff's announcements came hours after local authorities recovered the bodies of Woods and Clark, who were found shot to death along a hiking trail in Orange County over the weekend. Their bodies were found Sunday afternoon by men riding ATVs in the area. Lyric was a 9th grader at Cedar Ridge High School in Hillsboro, and Devin was a senior at Eastern High School in Mebane. The teens were described as acquaintances. Family members reported Lyric's missing Saturday afternoon to the Orange County Sheriff's Office. Just crazy. I just don't understand it. Kids. And then another kid killing kids. Like, what is going on in the world, ladies and gentlemen? Need some answers on that. And, you really have to wonder, a lot of the juvenile reform, does it do any good? Because although you can no longer charge a juvenile in lots of jurisdictions like they've done here in the state of Colorado directly as an adult, they can do what they call a reverse transfer hearing, saying we're going to send it back to the district court because this case is, well, egregious and requires the penalties of an adult. Let me know your thoughts on that. I mean, they're kids, but when you commit violent crimes, you really got to wonder, should you be treated as a kid? Let me know in the comments below. All right. How many times have you heard me say, let it go? Let it go. And the reason I say that, let me give you an example. Exhibit A. A 47-year-old Georgia attorney may spend the rest of his life behind bars for killing a man he believed threw a golf ball at his Mercedes-Benz and then running the man down with the luxury sedan. A Fulton County jury returned a guilty verdict against Brian Keith Schmidt on 1 count of second-degree murder in the death of Hamid Janagard. Now, Fulton County Superior Court Judge Melanie Leftridge handed down a sentence of life with the possibility of parole in a Georgia state prison. The defendant will be 81 years old by the time he is eligible for parole. Schmidt was initially charged with 2 counts each of felony murder and aggravated assault, as well as 1 count of murder. Records show that the jury found him guilty of 1 count of murder, while the 2 felony murder charges were vacated and the aggravated assault charges were merged for sentencing purpose. Now, it is alleged that Schmidt, on July 30th of 2019, hit Mr. Jangard with his Mercedes-Benz, causing Jangard to fall and hit his head. Investigators believe a road rage confrontation between the men escalated, culminating in Schmidt hitting Jangard with his car as he walked across the street. Schmidt reportedly waited for police to arrive at the scene and claimed that he only meant to talk to Jangard and never meant to hit him with the car. His defense attorney continued to make that argument throughout the trial and closing arguments, and stating that Mr. Schmidt did not intend to kill or assault or harm Mr. Jangard in any way, but it was just a tragic accident. Well, taking the stand in his own defense, Mr. Schmidt reportedly told jurors that he was driving home from work when he heard something hit his car. He then turned around and saw Jangard, who was allegedly bouncing a golf ball on the edge of his driveway while talking on the phone. The 2 exchanged words across traffic after Schmidt stopped his car in the road. Schmidt then turned abruptly into the driveway, striking a curb, a couple of trash cans, and Mr. Jangard. Schmidt reportedly claimed that he underestimated the car's turning radius when speaking with Mr. Jangard. It happens all the time, right? Well, the district attorney reportedly argued that Mr. Schmidt knew what he was doing and acted out of anger when he sped into Mr. Jangard. It was a violent death. It was a gruesome death, according to the district attorney. It was a death that left Mr. Jangard suffering in the hospital for 2 days until he was pronounced brain dead. Now, Mr. Schmidt, who worked as an in-house attorney at a company specialized in software development, had been a registered attorney in the state of Georgia since 2015. Don't you really think, looking back, you'd say, it's a car. It's inconvenient. You got to get a dent. But I'm assuming Mr. Schmidt had the necessary insurance that wouldn't be a big deal. And a jury didn't buy his story that it was just an accident. Oh, I just underestimated the turning radius of the car. Let it go. Okay? It's an inconvenience. I'm telling you, let it go. Road rage can change people's lives so quickly. I've seen it happen. We've all been there, but I'm telling you, take a deep breath. Namaste. Let it go. Finally, our dumb criminal of the day. A domestic dispute. How often have we seen those? Over, guess what? Some food. In this case, a takeout Chinese food order ended with a criminal charges being filed against a Florida man and his daughter, both of whom are accused of battering a third family member. Their police say that the melee broke out Friday evening at the residence in Wildwood, a central Florida city adjacent to the Village's retirement community. The home is occupied by Bruce Schnell, his wife, daughter Atlantis, and his son, who cops identified as the victim. As detailed in the police report, it is alleged that Schnell's family had ordered Chinese food, but the takeout containers were not labeled, which upset Schnell since he did not know which container of food was his. This is a problem that goes on every day. I've always said this about Chinese food. Why do they not label it, right? Because you got to open it up and look. Well, Schnell's son, according to police, said that he argued with his father and sister over the Chinese food due to the fact that the victim had eaten his father's food unknowingly. The dispute turned violent, the victim said, when his sister began punching him in the face. Schnell then allegedly joined the fracas, putting his son in a chokehold. Schnell's wife told cops she was in her bedroom when she heard crashing and yelling in the kitchen. When she entered the kitchen, the woman recalled stating that Atlantis, who's 25, was pummeling the victim who was being choked by Schnell. The battering, the woman added, ended only after she called 911. The victim had visible red marks on the front side of his neck and fresh bruising redness on his left eye, according to the police reports, who noted that neither of the defendants appeared to have any marks or bruises from this incident. Both Schnell and Atlantis were arrested for misdemeanor battery. Schnell was charged with domestic battery by strangulation, a felony, and each defendant bonded out from jail early Sunday morning. Look at that. A family that does crime together stays together. Except somebody's going to have to move out because usually the protection order doesn't require them to be in the same location. And they got upset about somebody eating their food. The daughter got upset about her brother eating her dad's food. And now there's felony charges pending against the dad. Are you kidding me? Let it go. Let it go. People got real problems in the world, not who ate my food. And see, this is a perfect segue. If they had ordered from CrimeTalkPrep.com, they would have had plenty of food to eat and nobody would have gotten battered. See? Could have saved everybody a whole lot of trouble. All right. Thanks for watching. I hope everyone enjoyed the show. I want to thank everyone for joining us last night on our live as well as our Patreon show. We made some predictions about the Lori Vallow Chad Daybell case that I hope I'm wrong. And the Magic 8 Ball made the same prediction. So we hope the Magic 8 Ball is wrong as well. All right. Thanks for watching. We'll see you next time on Crime Talk.